Hello landlords, this is Matthew Lyman coming back at you with the Landlord Advocates, where we help landlords become better landlords. For the last few weeks we have been perusing many social media sites such as Reddit, LinkedIn, Twitter, Instagram, and of course Facebook. We've been doing that looking at different landlord posts, landlord pages, landlord groups, and reading many comments on those regarding the awful situations that landlords are in during this COVID-19 crisis of tenants not paying rent, tenants destroying the property, courts not being open, eviction moratoriums in place. All of these variables that are preventing landlords from recovering their property or recovering the rent. One of the groups that we belong to on Facebook is called NY Landlords. We belong to about 11 groups on Facebook dedicated to landlords. And we interact a lot with them. We read the posts, we respond to posts, we respond to comments, we respond to comments on our comments. Well, the NY Landlords is a very productive, very interactive page that works with landlords, helps landlords. It's a very strong ally page. There are other ones, and we will talk about those in another video. But NY Landlords, if you're in New York, join that group on Facebook. Even if you're not in New York, if you're in Wisconsin, California, Texas, South Dakota, North Dakota, Washington State, a lot of the advice shared on that post, on that page, will help you as a landlord in your particular state or your particular county. We suggest that you join. Well, one of the things that we have seen, one of the things that we have read and commented to, is a common theme that landlords are providing advice to other landlords on what they should do with tenants who are not paying rent right now, that they can't evict, that the courts are not really hearing cases, that is very difficult. And the one thing that we've read, we have commented about, and we've said, no, don't do this, don't do that, don't. And that's one thing, as you see by the name of the video, the one thing that landlords should never, ever do, anywhere in the United States. There's one thing that landlords should never do is this. You should never do a constructive eviction. You might say, Matt, what's a constructive eviction? That's the legal term for constructive eviction, but you may know it better as a self-help eviction, an illegal eviction. It is one in which you do not seek judicial intervention to get your tenant to move out. Your tenant did not give you the keys, they have no intentions of ever giving you the keys, they're going to make you wait it out before they can get into court. If a tenant does not give you the keys back to the property, they are still your tenant. And you cannot do things to them to make them move out. You have to go and get a court order, a warrant or a writ of eviction, and give it to your marshal or to your local sheriff to have them vacate those tenants from the property. Some of the suggestions that we have read from landlords to other landlords have been a little funny and to the point where very dangerous. Some of the suggestions have been have the neighbors turn lights onto the tenant's property so it's all lit up at night. Have them blast different types of music that might be inverse to what the tenants really like to listen to. Do that to them. Well, the landlords may suggest, I'm going to move in with my tenants. You're not going to do that. They've suggested that. They've suggested to other landlords to change the locks on the door. Take the doors right out the hinges. Turn off the water. Turn off the hot water. Turn off the electricity. Some of you would say, rip off the meters off the house so they can't even get turned on if they want to. Do all of that. Landlords, you cannot do these. They are not allowed on every level in our nation, meaning hamlet, towns, villages, cities, counties, states. all the way up to the federal government. You cannot take these actions upon yourself to get your tenants to get out. You do that, you're opening yourself up to so much liability, you have no idea. But you will when we get done with this video telling you this. Some of them are ones that will cost you so much money that you might even lose your property. Before we get into that though, we suggest we would like if you would subscribe to our channel here on YouTube, hit the notification bell so that you're aware of other videos coming up, hit the like button, and of course we always like to see comments. We respond to those comments, and when you do that, when you send us comments and we respond, we might be helping other landlords in other areas so that they don't make the same mistakes. So please feel free to do that. The reason why you can't do these activities is that it is so illegal that it can open you up to thousands of dollars in liability and criminality to it. You can't do that. Allow me for a moment to step out of my role as the host of the Landlord Advocates and step into another role that I have, and that is the president of Ideal Legal Support Services, LLC, here in New York. We have over 1,200 landlords that are clients of ours. Many times they can contact us through the internet, through the phone lines, fax machines, or they even come into our office. And when they come into the office, they'll sit down at a staff member's desk, or maybe even mine, and they will tell us their problems that they're having with a tenant, and that they are angry, frustrated, baffled, dumbfounded, at wit's end as to what they can do. And they will tell us what it is that they want to do to their tenant to get them out. And we always tell them, on your side of the desk, we don't blame you. We don't blame you one bit for doing what you want to do to get back your property. Because this is just not right. $5,000, $6,000 in back rent. Moving everybody in. Moving in all the animals from Noah's Ark into the apartment. And just saying to the landlord, there's nothing you can do. Deal with it. On your side of the desk, we don't blame you one bit. But one of the things that we tell all of our people is on our side of the desk, you need to understand the ramifications of what it is that you want to do. We're going to tell you on our side of the desk what it is that you need to do. You don't have to do it. You can do whatever you want. But on our side of the desk, we suggest not to do that and to go through the legal means, the legal steps and procedures to get the tenant removed from the property. It may not happen as fast as you want, but it is the way that it is. If you go ahead and do a self-help eviction, tenants have many avenues out there to get help for doing what you may have done. Especially now, there's a lot of tenant advocacy groups out there that will help tenants who have been put in that position. Even though they may owe you 8 or 9 months worth of rent, you cannot do that. And they're going to go to those organizations, and those organizations are going to do things for them that the tenant may not even know that they can do. In particular, here in New York State, as it may be in other states and other counties, if you do a self-help eviction by changing the locks on the door, turning off the power to the house, turning off the hot water, restricting access to that which they were having access to when they weren't paying you the rent, could hit you with fines that you can't even believe. Here in New York State, as of June of 2019, if you were to do that, you can be hit with a fine of up to $10,000 for illegally locking your tenant out or causing a situation that the tenant must leave. It's up to $10,000, but we can most assuredly guarantee you that due to this COVID-19 situation that everybody's in right now, and even way after, let's say 5 years from now, you still can't do it. But here, we most assuredly guarantee that you will be hit with a maximum penalty. Whether it be here in New York State for $10,000 or $25,000 that might be in Idaho, or $3,000 that might be in Ohio, or $3,000 in Georgia, whatever it might be, you're going to be hit with that. And that's not where it ends. That's not where it ends. Our office has assisted landlords who have taken the eviction matter into their own hands. We had one who decided to turn off the power, and metal bracelets were put on his wrist, and now he's being represented for that. We have another one who was accused by the tenant of forcibly not allowing her to leave the property while he was there. The police were called. He was arrested and charged with some crimes that may have seen him in jail for a year or more. He came to us and said, help. Well, one of the members of our team, we have about 5 or 6 members on the team, is a very good attorney by the name of Mark Judah. Mr. Judah took this case on. It went to criminal court, police court, whatever court you may call it in your jurisdiction. And the arguments were laid out by the prosecutor's office, and the defenses were laid out, and the facts were laid out by the defendant's attorney, Mr. Judah. When all was said and done, the court examined all of the evidence, the arguments of Mr. Judah, and all of the charges that the landlord had faced, that the tenant had purported that my landlord did, were dismissed. He went home later on that day to his wife. Not every landlord is going to be that lucky. That landlord in that case had to pay for Mr. Judah to represent him. He had to pay. That took some time. He had to take time off from his job to deal with that. So you don't want to get yourself messed up with that kind of a situation. Again, landlords, don't change the locks on the door. Do not turn off the power. Do not turn off the heat in the winter time. Don't do any of those things, because you're just asking for a lot of trouble to be visited upon you. We know of a case in upstate New York. We're not going to say the county, but it was in Superior Court. The new landlord had bought a commercial property where there were 3 commercial tenants in there. The one commercial tenant had not been paying rent to the prior owner. So the new owner said, well, I'm not dealing with that. I'm not going to put myself in that position. No way. Well, that landlord decided to have a few of his buddies, whoever they may have been, and himself, went into that commercial tenant's property when the tenant wasn't there, and decided to expel all of his property from that establishment. Well, while that was going on, that tenant showed up. Well, as you can imagine, there was a lot of situations that happened with that. A lot of problems. Police were involved. Well, eventually, the tenant sued the new landlord. The new landlord had his attorneys. The tenant had his attorneys. They went to court to argue the case in front of the judge. The attorneys for the landlord argued why this was allowed, why the landlord should not have to deal with this. He didn't want to be put in the same position as the prior landlord, so he did what he did because he didn't want to lose any money. The attorneys for the tenant, they offered their arguments to the judge. It was a bench trial. It wasn't a jury trial, which means the judge would make the ruling in that case. The judge looked at all the information, looked at all the evidence, listened to all of the arguments, and eventually he made his ruling. And the ruling was this. The landlord's attorneys and their arguments to this judge were dismissed. He dismissed all of their arguments. And the basis for that being was that the landlord, the new landlord, had done what we tell you right now never to do, a self-help eviction. A constructive eviction was done by that landlord. So therefore, anything after that really didn't matter, because he prefaced his case immediately from doing something that was illegal. So anything that may have done legally after that, may have been, which it wasn't, but let's just say it was, doesn't matter because the case started out illegally. The eviction started out illegally. So the judge awarded the tenant the $30,000 claim in his case that's called compensatory damages. He claimed that he lost over $30,000 in merchandise, equipment, and lost revenue. The judge agreed with that. So he granted him $30,000 in compensatory damages. But wait a minute, landlord. Wait a minute. Whoa, 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 whoa. It gets much, much worse for that commercial landlord who did what he did. The judge also granted the tenant in that case punitive damages in the amount of $90,000. That's right, $90,000 in punitive damages was sanctioned against the new landlord for doing an illegal eviction, a self-help eviction, a constructive eviction. And told them that new landlord had to give $120,000 to that tenant for doing an illegal eviction. Now, in a residential area, in a residential apartment, you may not have to face any fines such as that. But if you do an illegal eviction like that and the tenant has to go to a hotel, and they've lost product, they've lost stuff in their refrigerator, whatever it may have been, the court will impose upon you that $10,000 fine or $5,000, whatever it is, in your jurisdiction. The money that the tenant paid for a hotel, say it'd be $200 a night, the judge will triple that amount, so they pay them $200 plus $600 on top of that, so now it's $800. Let's say you did it for a week or two. Take the $800 and multiply that by 10. That's $8,000. All because you were ticked off that this tenant owes you rent and you won't move. We hear you. We agree with you. It's not right. But in the long run, you may be satisfied by doing what you did, and I got my property back, that tenant's gone, I didn't have to go to court. You're done. I won. No, you didn't win. No, you didn't win. You lost because you're going to be paying more money later on for doing what you did. So if you take anything from this, when you want to do what you want to do and illegally evict the tenant right here, right now, stop. Stop. Go have a beer. Go have an ice cream cone. Go for a walk. And think about, in the end, what it will cost you for doing an unlawful eviction. It will cost you much, much more than the amount of rent that the tenant owes you or whatever damages they may have caused. And not only that, by you as a landlord doing these illegal evictions, you will be on the radar of code enforcement, the courts, the tenant advocacy groups. You will be being watched by those groups. Don't do it. Again, we appreciate your frustration, but don't do it. We're working on other videos right now. The laws are changing so much so fast with how to get rid of tenants and how to evict and how to start the processes. We're working on other ones right now. So, subscribe to our channel so you're kept up to date on those videos. Hit the like button, hit the notification bell. The more you subscribe, the more we can do for you. The more you watch, the more we can do for you. Again, landlords, number one, do not change the locks on the door. Do not illegally evict. Do not do any of that. And always remember, landlords, we here at the Landlord Advocates are here with you, and we are here for you. We wish you the very best. Take care.